Welcome back to Maximiliano Allende. I'm your host, and today we are not just looking at a headline, we are witnessing a seismic collision at the very heart of the American Republic. Imagine a moment where the highest court in the land looks down at the most powerful office in the world and simply says, "You have crossed the line." Recently, the United States Supreme Court delivered a historic ruling, striking down the sitting president's sweeping tariff program, declaring it unconstitutional from its very inception. What makes this moment extraordinary is not just the verdict itself, but the undeniable neutrality of the messengers. This was not a ruling handed down by a lower court with a partisan agenda. This was the Supreme Court, an institution fundamentally reshaped by this exact president, featuring 3 justices he personally appointed. Yet when forced to choose between political loyalty and constitutional boundaries, the court ruled that the bedrock of the law must hold firm. It was a resounding declaration that in a constitutional republic, no individual, no matter their office, stands above the legal framework. Traditionally, when the Supreme Court speaks, the executive branch listens. Presidents of the past have publicly bowed to the court's final word, acknowledging the structural boundaries that have kept the nation intact for over 2 centuries. But the response from the current administration was drastically different. The president publicly dismissed the highest court's ruling as a disgrace and immediately announced the existence of a backup plan. Stop and think about that phrase for a second. A backup plan for when the Supreme Court says no. This is exactly why you need to pay close attention. What we are observing is no longer a standard political disagreement. It is not a debate over global trade, the price of imported steel, or manufacturing jobs. We are watching a live stress test of the American constitutional system. We are seeing an executive openly challenge the institutional guardrails designed to restrain him. In the next few minutes, I will dissect precisely why this ruling is more significant than any economic chart you will see on the news, what this backup plan actually means for the balance of power, and why this is fundamentally a story about whether the Constitution will still govern how America operates in the years to come. To fully grasp the gravity of this constitutional earthquake, we must put aside our personal opinions on trade policy and dissect the legal anatomy of what just happened. How did the administration impose such massive global tariffs in the first place? And why did the Supreme Court decide that this foundation was built on sand? When the administration launched its sweeping tariffs against dozens of foreign nations, it did not go through Congress to ask for a new law. Instead, it bypassed the legislative branch entirely by invoking the International Emergency Economic Powers Act, IEPA, alongside other STEM statutes. The strategy was brilliant in its simplicity. The president declared a national economic emergency. Under this emergency framework, the executive branch claimed broad, unilateral authority to regulate international commerce to protect the nation. Therefore, the tariffs were deemed legal. There were no congressional debates, no legislative compromises, and no votes. It required nothing more than an executive declaration and a stroke of a pen. For a time, this argument survived the lower courts. It survived long enough to completely reshape global supply chains, alter international relations, and force entire industries to restructure their financial models based on tariffs that, as it turns out, were never constitutionally authorized. When the Supreme Court finally placed this strategy under its legal microscope, they dismantled it. And they did so using one of the most fundamental pillars of American law, the non-delegation doctrine. This is a constitutional principle which states that Congress cannot simply hand over its lawmaking powers to the executive branch without providing incredibly clear, strict, and specific limitations on how that power can be used. The court did not rule on whether tariffs are good or bad for the economy. Economists can argue about that for decades. The court ruled on a matter of pure, unadulterated process.
Article 1, Section 8 of the United States Constitution is crystal clear. It is the Congress, not the President, that holds the exclusive power to regulate commerce with foreign nations. It is perhaps one of the most explicit grants of authority in the entire founding document. The justices determined that the emergency acts, as utilized by this administration, were not being treated as targeted temporary tools. Instead, they were being weaponized as a permanent blank check. If the court had allowed this to stand, it would have permanently transferred the power of international trade from the legislative branch to the presidency. It would have set a precedent that any future president could simply declare an economic emergency and rewrite the nation's tax and trade laws without ever needing a single vote from the representatives elected by the people. The Supreme Court drew a line in the sand. They reminded the nation that the Constitution means exactly what it says. Congress writes the laws, and the president executes them. The two roles are strictly separated, and they are not interchangeable. But as we are about to see, striking down the legal foundation of a multi-billion-dollar economic policy is only half the story. The real crisis begins when the executive branch decides that the Supreme Court's no is merely a suggestion. Welcome back to the analysis. As we established, the Supreme Court has stripped away the legal foundation of the executive branch's entire tariff architecture. But in the real world, judicial rulings are not just ink on paper. They are the trigger for massive, tangible shockwaves. Let us look objectively at the immediate economic domino effect. If the highest court rules that the tariffs were implemented beyond the president's constitutional authority, it means those tariffs were, legally speaking, void from the start. We are no longer dealing with a theoretical debate. We are looking at a retroactive legal vacuum. What happens to the billions of dollars in tariffs that corporations have already paid? Every company that restructured its supply chain, every business that paid inflated import taxes, now has potential legal grounds to demand a refund. What happens to the bilateral trade agreements and diplomatic negotiations that were strong-armed into existence using those very tariffs as leverage? They are now built on a legal foundation that simply does not exist. The economic disruption generated by this ruling will take months, if not years, to fully materialize. Global markets hate uncertainty, and right now, the United States trade policy is the definition of legal chaos. Yet the most profound disruption is not economic, it is institutional. When a president builds their entire economic identity around a specific policy, having it dismantled by the Supreme Court is a devastating blow. But historically, the unspoken rule of the American Republic, the very standard that has held the democracy together through wars and depressions, is that the president accepts the court's ruling as final. They might disagree with it, they might heavily criticize the rationale, but they operate within the newly defined boundaries. That standard has just been shattered. Within hours of the decision, the president publicly labeled the ruling a disgrace, portraying it not as a constitutional correction, but as a politically motivated attack. He signaled to the nation that he views the independence of the judiciary as legitimate only when it produces results he agrees with. And then came the phrase that should keep every constitutional scholar awake at night, the announcement of a backup plan. When the executive branch decides that the Supreme Court's verdict is unacceptable, what exactly does a backup plan look like? This brings us to the true crisis of our time. When we analyze the mechanics of government, there are essentially three paths the administration can take in the wake of this Supreme Court defeat. Each path leads the nation down a drastically different future. The first path, constitutional compliance. This is the legitimate democratic route. The president goes down Pennsylvania Avenue, stands before Congress, and formally requests the legislative authority to impose these specific tariffs. Congress drafts a bill, establishes clear boundaries, the House and Senate vote, and the President signs it into law. This is exactly how the framers of the Constitution intended the system to work. The problem? This path requires sharing power. It requires congressional approval, which means it requires time, debate, and compromise. It completely strips the executive branch of the unilateral, immediate control it desires. A president who uses tariffs as a swift weapon of foreign policy will have zero interest in waiting for a divided Congress to grant him permission. The second path, the legal shuffle. If Congress is too slow, the administration might attempt to reconstruct the exact same tariff program using different legal loopholes. They could invoke Section 232 of the Trade Expansion Act, citing national security threats, or Section 301 of the Trade Act to combat unfair trade practices. Essentially, they would be rebuilding the exact same house on a slightly different yet equally shaky legal foundation, daring the courts to strike it down all over again. The danger of this path is that it paralyzes global commerce. Every trading partner, every foreign government, and every multinational corporation will know that America's trade policy is in legal purgatory. Why would any nation make concessions to the United States when they know the administration's policies might be ruled unconstitutional again in 6 months? The third path, the gray zone of defiance. This is the path we must watch with the utmost vigilance, because it is the path that transitions a legal dispute into a full-blown constitutional crisis. Based on the president's public rhetoric, calling the court a disgrace and treating it as an adversary, the backup plan might simply be quiet, bureaucratic defiance. Imagine this scenario. The executive branch does not hold a press conference to openly declare rebellion against the court. Instead, they simply use the immense, sluggish labyrinth of the federal bureaucracy to continue enforcing the tariffs while tying up the legal challenges in endless appeals and administrative delays. They maintain the economic reality of the tariffs, even as their legality is formally denied. And here is the terrifying truth that nobody talks about. The Supreme Court has a fundamental structural weakness. They have a gavel, and they have the moral authority of the law, but they have no army, they have no police force, they have no treasury. The court is entirely dependent on the executive branch to enforce its rulings. In the 1830s, President Andrew Jackson famously defied the Supreme Court, allegedly stating, "John Marshall has made his decision, now let him enforce it." He exposed the fragile gentleman's agreement that keeps the republic functioning. If the current administration chooses to treat the Supreme Court's ruling as merely an inconvenient obstacle to be managed, rather than a hard boundary to be respected, the court has very few practical tools to force compliance. We are standing at a crossroads where the executive branch is actively testing whether the separation of powers is a physical barrier or just an illusion. And the decision they make next will determine the shape of the American government for generations.
This brings us to the ultimate crucible of this entire ordeal. The executive branch is testing the fences, and the judicial branch has drawn a line. But there is a third actor in this constitutional drama, one that has been noticeably quiet: the United States Congress. Right now, the legislative branch is facing a historic moment of institutional accountability. If the president's power to impose unilateral tariffs has been struck down, Congress has the ability to restore a portion of that power through legislation. But they can only do so if they are willing to assert their own constitutional role. If Congress simply rubber stamps a new law that hands the executive branch broad, unchecked authority to impose tariffs at will, they are essentially abdicating their own constitutional power. They would be willingly surrendering the very authority the Supreme Court just fought to protect on their behalf.
To survive constitutional scrutiny, any new trade law must contain real limitations, genuine legislative oversight, and actual congressional control. That is what the architecture of the Republic demands. Whether the current Congress is willing to do the hard work of governing, or whether they will simply capitulate to executive demands, is the question that will define this chapter in American history. But as we conclude this analysis, we must look beyond the politicians, beyond the judges, and beyond the fluctuating numbers of the global markets. The profound disruption we are witnessing today, the disruption that matters far more than any quarterly profit report or trade deficit, is the disruption of the constitutional order itself. Because if the precedent established in this moment is that Supreme Court decisions are merely optional for a president who disagrees with them, then the next president will know it, and the one after that. The damage that such a precedent inflicts upon the institutional credibility of the United States will outlast any tariff regime for generations. So I leave you with one simple, grave question to ponder tonight. If the highest court in the nation can tell the most powerful executive in the world that they have overstepped their constitutional authority, and the executive's response is to call it a disgrace and activate a backup plan to bypass the law, who actually enforces the Constitution? The answer is not a Supreme Court justice. It is not a senator, a general, a bureaucrat, or a White House lawyer. The answer has always been and will always be the citizenry. A constitutional democracy does not exist on parchment. Ink cannot stop the overreach of power. The Constitution exists solely in the collective will of the people to demand that the leaders they elect operate within the framework of the rules. The exact moment a society decides that the result is more important than the process, that winning the political game is more important than how the game is won, is the exact moment the Constitution ceases to be a living, breathing constraint and becomes nothing more than a historical artifact. We are living in that moment right now. How the nation responds to this friction will echo long after the specific tariff percentages are forgotten. Do not let the partisan noise distract you from the structural reality. This is not about the economics of trade. This is about the survival of the legal framework that underpins everything else we hold dear. I urge you to stay vigilant, stay deeply informed. If you found value in this analysis, share this video with someone who needs to understand what is truly at stake here. The survival of a republic requires an educated public. Thank you for watching. I am Maximiliano Allende, and this story is far from over. I will see you in the next analysis.